Okay, so this is something that I've been thinking about for a while, and I'm posting this one more as a question, okay? Because I don't know the answer to this. I have an opinion about it, but I'm not sure I know the answer, okay? So my question to you all out there is that for something to be considered a law, it has to meet requirements, okay? One requirement is it has to have an enacting clause. The next requirement is that it has to have a positive law citation. Okay, so what happens when a law does not have those things? Is it a law? So something can have, such as a title, can have something called an enacting clause, but not have a positive law citation. So if it doesn't have a positive law citation, legally, according to the requirement of a positive law citation, it's not a law, and it cannot be used as evidence of being a law in any of the courts. So if you have a title that has an enacting clause but not a positive law citation, the enacting clause just tells you by what authority it's been enacted. So, such as Title 34 U.S. Code, crime control and law enforcement. Okay, so crime control and law enforcement does not have a positive law citation. A positive law citation is required within the code or the title so that you know that it's legal evidence of the laws having been made and can be used as evidence in the courts of the United States. So when something such as Title 34 has an enacting clause but not a positive law, it's saying who enacted it, but it's not saying that it's a law. The popular democratic notion or idea or theory is that if something is not prohibited, then it's allowed. And the popular libertarian and for some Republican idea is that it's only allowed when it's in the Constitution. Only the things in the Constitution are allowed. And we know from various readings, or at least I know from various readings, that if it's not in the Constitution, you can't do it because the law tells you what you can do. The law does not tell you everything that you cannot do. And so the democratic theory that if it's not expressly prohibited, then it's allowed is false, and it's a lie, and makes no sense. Because if something not written is allowed, then we wouldn't need to write things down. Everything would be allowed. And then they have this idea of a positive written thing, or this means posit, but they also have codes that are written to say what you can't do. So what you can do is written and what you can't do is written, and the Constitution says what you can do and what you can't do. It says the federal government can do these things and the states cannot do these things. Okay, and everything else that the states cannot do, they can do. And that means that everything that the federal government can do, whatever's outside of that, it cannot do. And so we have to use proper reason. So their idea that if it's not in the Constitution they can do it is false. And they base a lot of their ideas on what they can do on that theory. So they write a lot of things outside the Constitution that they're actually not supposed to do, that they never had power to do. And so to get you to comply, they have you sign papers, they have you apply on applications, they advertise for you, to get you to do these things. They lie to you and they tell you it's the law, and they just do all kinds of stuff because they claim that the Constitution doesn't say they can't do it. All right, so a positive law citation means that it's legal evidence of the law having been made. That doesn't necessarily mean that it's constitutional. My opinion is that if it has a positive law citation, then that meant that it was passed because it was in harmony with the Constitution. An enacting clause simply tells you by what authority someone enacts something. And an enacted clause alone does not mean that something is a law. So here's my question. At the federal level, they have crime control and law enforcement, Title 34 U.S. Code. It does not have a positive law. So here's a mathematical symbol also used in symbolic logic, which is what attorneys, lawyers, and judges use. It's not positive. It's not equal, positive. Dang it, if only I could write. It's not equal positive law because it has no positive law citation, and therefore it's outside your oath. Because without a positive law citation, there's no legal evidence of it being a law. So if a police person or law enforcement is supposed to have an oath to uphold and defend the Constitution, how can they uphold something that's not a law? So how are they given the authority to act outside the Constitution when the Constitution requires an oath for public officers and employees? And even if it didn't require an oath, do they have an oath to uphold and defend the Constitution? And if they have an oath to uphold and defend the Constitution, then when they uphold a law or uphold a title not a law outside the Constitution, not in harmony with the Constitution, are they acting outside their oath, even if they're not required to have one? If they have one and they're acting outside their oath, are they in violation of the Constitution? So this is sort of one of those elliptical things where it goes round and round and round. They say, well, I have to do my job. I'm just doing my job. My job is this, to follow this. But then you have an oath to the Constitution. And this is not constitutional. So if this is not constitutional, are you following your oath? So can you be both under oath and following a title which is not a law? Can you do that? Is that possible? If this is not a law, then there's no evidence that it conforms to the Constitution, which is the law. And if it doesn't form to the Constitution that is the law, but you have an oath to follow the Constitution, can you then follow something that's not a law? Is this possible? Is it possible to do both follow the law and follow not the law? When not the law is not the law because it doesn't follow the law. So this is not the law because it's not in harmony with the Constitution. And we know that because it doesn't have a positive law it doesn't have a positive law citation, meaning that there's no evidence, no legal evidence of it being made a law. So if it's not a law, how can you have an oath to the Constitution and then uphold not the law? I don't know if I said that right, but you understand what I'm getting at here, I hope. You have an oath to follow the Constitution, an oath to the Constitution, yet you're saying you're following the law, and you're saying this is a law, but this has no positive law citation to show that it is a law. So you say you're just doing your job, but then you have an oath, which means you're not following your oath. So which is higher, doing your job or following your oath? Well, the Constitution is higher, right? So if the Constitution is higher, then you can't do this and be under oath, because this is not in harmony with the Constitution. So if you have an oath, you have to follow the real law and not just a title. Because without a positive law citation, this is nothing. This is just something in writing. It's not a law, and there's no legal evidence of it having been made a law that can be used in the actual courts created by the Constitution, courts of the United States, the courts created by the Constitution. That means they have to bring you in, if you violate this, under a different court, a court outside the Constitution. But then they're not following an oath. So what do we do? How do we fix this? My only purpose is education. I'm not telling anyone to do anything that will get them in trouble or hurt anyone else. I would never ever do that. My only effort is to educate. So that's my question. Can you abide by your oath and take your oath seriously and honor your oath and follow a law or follow a title not made law and has no evidence of being a law because it's not in harmony with your oath? Is that possible? I don't think so. What do you think? Let me know in the comments.